Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. It's been a minute since we did a live filing in this case, but we now have Wayfarer and Justin Baldoni's response to Ryan Reynolds' motion to dismiss, and I'm going to go over that with you guys in just a couple minutes here. I'll let some people filter in. If you missed it, in the meantime, I've been working on a couple projects. So those of you who sent me in your voice notes or you sent me your messages of support for Justin, I'm working on a series. I put out a couple videos already. And if you haven't, you might want to check that out. It's pretty cool just to hear from some of the people in our community here. So some of the people you're watching with when we go through these filings are some of the people who spoke out in support of Justin in that project. So if you want to be included in that, I'm still working on it and I still need a little more to work with. Please do email me at the email address on my YouTube channel and in my bio. It's laccurate@gmail.com, LACKURATE@gmail.com. All right. Let me pull this up real quick. Okay. I won't waste too much time here, guys. I'm just going to give it a little bit longer for people to filter in. Not too long, though. And this is not an April Fool's joke. I can't remember if I said that already, but I was actually watching before I started the stream. Sorry, I was actually watching or starting to watch that documentary that just came out yesterday, was it, or last night? Because I'm gonna put together a little review and show like where I feel like it's lacking and where I feel like it's not really fairly portraying the facts and that kind of thing. Obviously, I've not finished that, but I'll get back to it as soon as we're done here. Hi, Lauren, your project rules sitting speakers. Thank you, Ricardo. All right. So, if you'll recall, it's been about 2 weeks since Ryan Reynolds filed his motion to dismiss. Blake Lively filed her own motion to dismiss, but not until a little bit after. So they have a couple more days to respond to hers. But this is the response from Justin, Jamie, Aiden's with us, Wayfarer, Melissa, Nathan, Jennifer Abel, the whole shebang. So, hey Kai, what's up? All right. Consolidated plaintiffs, Wayfarer students. You know what? We already know who this is, so we don't need to go through that. Okay. Introduction. Oh no, God! Oh no! Oh God! Okay, we're just gonna shots are we're just gonna keep firing shots here. All right, then. What could help except for Red Bull, right? They're quoting Ryan Reynolds now because Ryan Reynolds and Blake and all them were quoting Justin in their filings. So I guess we're just gonna get right into that, shall we? I like that. It's a little sassy. Okay. I've realized that I'm too big to fail at this point, so I just crush my enemies and drink their blood. Ryan Reynolds, July 12th, 2024. Reynolds pretends that the Wayfarer party's first amended complaint fails to set forth any basis for his liability, and that he merely acted as a supportive spouse. Not so. The FAC specifically alleges ample facts to support the Wayfarer party's claims against him, based on both his direct actions and his liability as a co-conspirator. The motion fails to show the Wayfarer parties fell short of their pleading burden under Rule 12b-6 and the Twombly-Iqbal standard. California law applies to each of the Wayfarer parties' claims, but under the law of either New York or California, the Wayfarer parties have pleaded defamation and tortious interference claims against Reynolds sufficient to defeat dismissal. This is particularly true where, as here, Reynolds has superior knowledge of the facts underlying the Wayfarer party's claims, given the early stage of discovery. Wait, what is this? Oh, for the footnote, they're citing his skincare regime alone would bankrupt you. Ryan Reynolds and Hugh Jackman bring banter and bromance to London. Okay. I've never seen that article, but it's not that interesting to me. Okay. In the alternative, any defects or inartful pleading in the FAC can be remedied by amendment, which is freely allowed, and the Wayfarer parties have gained additional information to plead further facts to support each of their claims against Reynolds, as well as the need to apply California law. Furthermore, the Wayfarer parties can amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. Mooting, I like that word. Helene, thank you for the 50. Is it okay to send a written note rather than a voicemail for your compilation? Yes, you can do that. Your work on it so far is beautiful. Anyone who's willing to send in their voice, that'd be great, but I can take written notes. I'm working with that too. So thank you very much, Helene. All right. Furthermore, the Wayfarer parties can amend their complaint to more fully incorporate the allegations of Exhibit A, which is that timeline of evidence, into the body of the complaint, mooting the motion to strike. Finally, even in the extremely unlikely event that the court determines dismissal without leave to amend is appropriate, Reynolds is unable to recover his attorney's fees as neither California nor New York anti-SLAPP laws apply here. In short, the motion should be denied. In the alternative, the court should grant the Wayfarer parties leave to amend their complaint because any defects in the First Amendment complaint are easily cured based on the facts now known to the Wayfarer parties. Oh boy. Okay. So we have the legal standard and factual background here. And let me just make sure I haven't missed anything that would be relevant in the meantime. Because this just came out not too long ago. Yeah, we're good. Because occasionally there'll be another memorandum or a statement or something. So, pursuant to Federal Rule of Civil Procedure 10C, the Wayfarer parties incorporate by reference their allegations in the First Amendment complaint and their recitations of legal standards and factual backgrounds in their oppositions to the Rule 12b6 motions of consolidated defendants Leslie Sloan and Vision PR. Oh, and the New York Times. I can't forget about them. Argument. A, the FAC gives adequate notice to Reynolds under Rule 8. Reynolds incorporates by reference the arguments made by other parties that the FAC contains impermissible group pleading. In response, the Wayfarer parties incorporate their responsive arguments from their oppositions to the motions to dismiss of the Sloan parties and the New York Times and reiterate that any defect can easily be cured by amendment. B, California law applies to the Wayfarer parties' claims against Reynolds. The choice of law rules of New York, the forum state, apply. Okay. The first step is to determine whether the laws of New York and California conflict. An actual conflict exists where the applicable law from each jurisdiction provides differing rules that have the potential to affect the outcome of the case significantly. The laws of New York and California conflict as to each of the Wayfarer parties' claims against Reynolds for defamation, false light invasion of privacy, tortious interference, and civil extortion. As to false light and civil extortion, the conflict between the two states' laws is total. California recognizes the claims while New York does not. Okay, and you guys know, I'm not a lawyer, so I'm going to skim through some of this case law stuff that I'm sure Omar, the Delta lawyer, my friend who comes on my stream a lot, and the two lawyers, I'm sure they'll be going over it. If not tonight, then tomorrow. So, the laws in New York and California also conflict with respect to defamation. California extends no greater protection to opinions than does the United States Constitution, while New York law, by contrast, in excess of the United States Constitution, provides for absolute protection of opinions. As New York and California laws conflict, the court must determine which law to apply to each claim. Under New York choice of law rules in defamation cases, the state of the plaintiff's domicile will usually have the most significant relationship to the case, and its law will therefore govern. Although the preference for the plaintiff's domicile is not conclusive, the significant contacts in a defamation case are almost exclusively the parties' domiciles and the locus of the tort. Okay. The interest of a state in a defamation action is significant and incontrovertible where the plaintiffs are citizens of that state and live and conduct their business there. Though New York may have some interest in this action because Reynolds resides in New York, California has a much more significant interest because nearly all of the plaintiffs are residents of California or have their principal place of business there. The two corporate plaintiffs, Wayfarer Studios and It Ends With Us, are both incorporated and or have their principal place of business in California. The plaintiffs suffered injury to their reputations in California, and the economic losses to the plaintiffs were felt in California. Okay. How are we doing, guys? Good so far? Chai H, thank you for the $10 super sticker. I appreciate you. Oh yeah, no, and I don't know if you guys have followed the Laura Owens Clayton Eckerd case at all. Dave Neal helped me get into YouTube when I first made a video about that case, but it's obviously something that is important to me, so I'm going to be covering that as well tonight. I just got a message from my buddy Bruce who watched the latest in that. So, citizen journalists, what's going on? All right, let's keep reading. Sorry. In addition, the underlying New York Times article, which is in many respects the genesis of this entire action, is purportedly based on reporting relating to Lively's complaint filed with the CCRD, which asserts claims for violations of California's law. The FAC states a claim for defamation against Reynolds. Where defamation is clear on its face, it is defamation per se, and damage is presumed. Okay. To plead defamation, a plaintiff must allege 1. A written or oral defamatory statement of fact concerning the plaintiff. 2. Publication to a third party. We have that. 3. Fault, either negligence or actual malice, depending on the status of the libeled party. 4. Falsity of the defamatory statement. And 5. Special damages or per se actionability. The court must decide only whether the statements alleged to have caused plaintiff injury are reasonably susceptible to the defamatory meaning imputed to them. Okay. The FAC, and we're at 1 here, the FAC sufficiently identifies Reynolds' defamatory statements of and concerning Baldoni and the other Wayfarer parties. Reynolds' contention that the FAC fails to identify defamatory statements he made fails on its face. The federal rules require that each pleading be specific enough to afford the defendant sufficient notice of the communications complained of to enable him to defend himself. Reynolds must have confused the rules of pleading with the rules of evidence. Okay. The FAC alleges that at least twice, Reynolds stated to WME executives, Baldoni's and Wayfarer's talent agency, that Baldoni is a sexual predator, and that, by implication, WME was in business with a sexual predator. The first statement was on July 15th, 2024, when Reynolds contacted Baldoni's agent, Danny Greenberg, for the purpose of making these defamatory statements. Oh, so he okay. Damn, I didn't realize it was that direct. That's bad. On the call, Reynolds referred to Baldoni as a deranged predator. Hilarious how this is playing out in the public eye, because have you seen what you did to your own children? I don't know, man. I don't get into that too much, but still. Hearing or reading or seeing this stuff and just knowing the background of what these people have done recently now, it's just kind of wow, you're such a piece of crap, actually. Okay, and warned Greenberg that Baldoni should not attend the film's premiere the next month because no one wants him there. Yikes. The second statement was on July 22nd, 2024, the Deadpool and Wolverine premiere, when Reynolds told a senior WME executive that by representing Baldoni, WME was doing business with a sexual predator. So this is one I knew about. This one I might have heard vaguely about, the actual phone call to his specific agent. I don't know if I actually knew about that or not, but I just want to double check really quick, because the first statement was on July 15th. The second one was a week later on July 22nd. The quote in the beginning of this motion, or the filing, not the motion. Was from July 12th. Okay. And yeah, same year, definitely. So yeah, so that was just a few days before he called his agent and said that shit. Damn. That's so crazy. Oh, thank you, April. Hit a like. The ratio is looking kind of crazy right now. I would appreciate that. Thank you. All right. So that's pretty nutty, right? These allegations are more than sufficiently specific, identifying the speaker, the listeners, and why, where, and when the statements were made. Given the specificity, it is unclear why Reynolds cites cases involving allegations so threadbare as to omit the time, place, speaker, or listener. As to the other Wayfarer parties, the FAC alleges that Reynolds worked in concert with Lively and the Sloan parties to publicly and falsely smear them. Reynolds and his co-conspirators made statements to third parties, including at least to the New York Times, that the Wayfarer parties engaged in, permitted, and or failed to prevent sexual misconduct towards Lively and retaliated against her for reporting the alleged misconduct, including by spreading lies to damage Lively's image. Reynolds, with Lively and the Sloan parties, told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, knowing that the newspaper would publish. A statement underlying a defamation claim must specifically refer to or be of and concerning the plaintiff. Okay. There is no question that requirement is satisfied. As alleged, all the Wayfarer parties have become figures of infamy because of Reynolds' statements, which were widely disseminated and understood to refer to them. Furthermore, the of and concerning requirement is an issue of fact for the jury to decide, and the court may dismiss an action only where the statement is incapable of supporting a jury's finding that it refers to the plaintiff. This is not a case in which a jury would be incapable of finding that statements at issue refer to each of the Wayfarer parties. Any doubts raise a question for the jury, not a question of law for the court. The Wayfarer parties' allegations also implicate the small group exception of the group defamation doctrine. An individual belonging to a small group may maintain an action for individual injury resulting from a defamatory comment about the group by showing that he is a member of the group. Here, there are 7 Wayfarer parties, well below the ceiling of the small group exception, and Reynolds defamed them all. Cat Lady Ballerina, thank you for the $2. Hi, back. What's going on? I don't follow this case, so I have nothing sassy to say. Hey, just you being here is good enough, right? Thank you very much. I appreciate it. April Love, thank you for becoming a member. Appreciate you. All right. Number 2, Reynolds' defamatory statements are not unactionable opinion. How are we doing, guys? I need another sip of Red Bull. It's almost 9 o'clock. It's like my bedtime now. Well, it was since they stopped filing things. I don't know if you guys remember, but on March 20th, the due date for all these responses, I was up until whatever hours of the night. And I had done that so many weeks in a row with these filings that having the last week or week and a half off, I was just like, oh my God, I can start acting like an old person again. I'm going to bed at 9:30 sometimes. All right. Under California law, to constitute defamation, the offensive publication must state facts rather than opinion. A statement is defamatory only if capable of being proved true or false. Statements do not imply a provably false factual assertion, and thus cannot form the basis of a defamation action if they cannot reasonably be interpreted as stating actual facts about an individual. But a statement of opinion is actionable if implicitly based on undisclosed facts. Whether the statement is fact or opinion is for the jury to weigh. Slaughter v. Friedman. I think it's a different. Is that the same Friedman? That's going to be a different Friedman, right? I don't know. Here the question is whether a fact finder could conclude the published statements imply a provably false fact. The court applies a totality of the circumstances test in which the court reviews the language of the statement and the context in which the statement was made. If a statement is factually specific, earnest, or serious in tone, or the speaker represents himself as unbiased, having specialized or first-hand experience, or having personally witnessed abhorrent behavior, a little bit of that going on, this may signal that there's a factual basis for the accusations. Courts applying New York law generally consider 1, whether the specific language and issue has a precise meaning which is readily understood. 2, whether the statements are capable of being proven true. And 3, whether the full context of the communication in which the statement appears is such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. New York courts focus on the overall context in which the complained of assertions were made. Context includes not only the immediate context in which the disputed words appear, but also the larger context in which the statements were published. Okay. If a statement contains opinion, the court must then examine whether the statement is pure opinion, and thus non-actionable, or mixed opinion, and therefore actionable. The actionable element of a mixed opinion is the implication that the speaker knows certain facts, unknown to his audience, which support his opinion and are detrimental to the person about whom he's speaking. The dispositive inquiry is whether a reasonable reader could have concluded that the statements were conveying facts. I think that applies here, don't you? Reynolds' attempt to recast his statements as opinion is belied by context. These statements were statements that at least implied undisclosed facts. There's a footnote here. Why don't we? Oh my God, it's a long footnote here. So why don't we take a quick peek at that before we move on? Amanda Sherbert, thank you for the $20 super sticker. You guys are awesome. Thank you. Totally worth going to bed late tonight. All right. Where do we just leave off? All are susceptible to a defamatory meaning, namely that Baldoni had committed egregious sexual offenses that warrant the label of sexual predator. See Partridge versus State, and it says, being wrongfully branded as a sexual predator is defamatory as one of the most loathsome labels in society, and that is definitely true. Especially in Hollywood, where the whole Me Too thing, picked up around 2020, so. Okay. And they're citing a case here that says it's reversing order granting motion to dismiss based on allegations that defendant called plaintiff a sexual predator to members of the women's tennis team. I never heard of that. Context also matters. Oh, we forgot about the footnote. Well, when I say we, I mean I. I went to look at the footnote and I read the comments instead. I'm sorry, guys. Okay. The case law cited by Reynolds, all of which is flatly inapposite, demonstrates the importance of viewing statements in their proper context. Okay. So it looks like, again, this is going to be, there's a lot of case law stuff here. So I'm going to leave that one for the lawyers, guys. Okay. Context also matters. Reynolds made the statements to key WME figures in an effort to force WME to drop Baldoni. Okay. Reynolds' argument that his deep disdain for Baldoni precludes a defamatory meaning to his words is illogical. See motion at 11. Okay. That deep disdain, which Reynolds seems to view as exculpatory, supports an inference of actual malice. All right, moving on to number 3 here. Reynolds' defamatory statements are not substantially true. One sec. All right. Reynolds argues the defamation claim fails because his alleged statements are substantially true. Fuck off. I mean, fuck off, honestly. But truth is a question of fact for the jury. The only exception when substantial truth is evident to the court is not the case here. And they're citing Dare America. Okay, interesting. Taking the allegations in the First Amendment complaint as true, as the court must on this motion, the court cannot conclude as a matter of law that 1, Baldoni is a sexual predator, thank God, or 2, the Wayfarer parties smeared Lively to retaliate for her disclosure of supposed misconduct. These propositions are expressly denied in the FAC with proof. Reynolds' statements have a different effect on the mind of the reader or listener from that which the pleaded truth would have produced. This case is not one of slight inaccuracies of expression. I'll say, yeah. Reynolds first argues that the FAC alleges facts that a reasonable observer could well consider predatory. What the fuck? I forgot about that. Okay. He next argues that a review of extrinsic evidence, specifically Baldoni's book, podcast, and YouTube appearances, are a factual basis for his assertions. And if you guys haven't seen I did a short video as part of a larger project that I'm working on with a lot of Justin's statements, clips, whatever on YouTube that really show more of who he is. And if you haven't seen it yet, you should check that out because, like I said, it's just it was like a 2-minute video, which is part of something larger that I'm working on. But it's really good to hear from him and his wife and from Jamie Heath and from Justin's dad and see how they interact with each other and how sincere they are. So just saying. Toy Nguyen, I hope I said that right. Nguyen. I'm not sure though. Thank you for the $20. Coffee money, keep up the great work. Thank you very much. I appreciate you. Okay. Let's see. Reynolds' first argument collapses upon any scrutiny of the FAC. Reynolds points to 1, a conversation Baldoni had with Lively at Sony's direction about her wardrobe choices. 2, a suggestion from the film's intimacy coordinator relayed to Lively by Baldoni as Lively would not meet her about the mechanics of a particular intimate scene. 3, calling a costume sexy. 4, hiring a Shakespearean-trained actor with an MFA in acting to play a doctor. And so that's what they are like complaining about. Justin hired his friend to play that. No, a Shakespearean-trained actor with an MFA in acting. 5, Jamie Heath, not Baldoni, showing Lively in preparation for a birth scene, a single clip from a home birth video depicting Heath's newborn son. And 6, Baldoni's purported failure to deny biting and sucking of Lively's lip, even construed in the most uncharitable light, which would be inappropriate here. These admissions do not show Baldoni as a sexual predator. Reynolds' second argument is barred, as it requires the court to consider extrinsic evidence not properly before it on a Rule 12b6 motion. To prove that Baldoni is a sexual predator, Reynolds draws on excerpts from Baldoni's book, YouTube videos, and podcast episodes, none of which are in the FAC. Reynolds' statements to WME executives did not refer to Baldoni's past statements. As alleged in the FAC, Reynolds was referring to what purportedly happened on the set of It Ends With Us. Wait, what? Okay. Okay, I get it now. Okay. Sorry, my brain went somewhere else when I first read that, so I had to go over it again. Okay, yeah, it makes sense now. Reynolds' continued effort to smear Baldoni is irrelevant, given that submission of evidence is not proper on a motion to dismiss, because it is only the sufficiency of the pleadings that are at issue. On a Rule 12b6 motion, if matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment under Rule 56. All parties must be given a reasonable opportunity to present all the material that is pertinent to the motion. Okay. Jordan says, anyone who's been a fan of Justin and Jamie's podcast knows exactly how psychotic it is that Ryan tries to use excerpts from there to support these insane claims. I've been watching a lot of that lately, and I agree. So it's pretty crazy. All right. There are a few narrow exceptions, including for written instruments attached as exhibits, and courts will sometimes consider documents that a plaintiff had either in its possession or had knowledge of and upon which they relied in bringing suit that were integral to its complaint. Okay. But the extrinsic evidence Reynolds relies on was not incorporated into the FAC or integral to it. No, he only included that to be a dick. So yeah, the defamation claim against Reynolds has nothing to do with Baldoni's book or the other extrinsic materials Reynolds raises. Reynolds' request is thus distinct from submissions by past defamation defendants of the defamatory material, even when such materials were not directly incorporated into the pleadings. The FAC does not rely heavily upon the terms and effect of the material submitted by Reynolds. Here, the court may exclude the additional material and decide the motion on the complaint alone, or it may convert the motion to one for summary judgment under Federal Rules of Civil Procedure 56. All right, we're moving on to number 4. The Wayfarer parties need not plead special damages because Reynolds' statements are defamatory per se. Hey, Winks, what's up? Bad Duck, thank you for the $5. What does a butch lesbian spider like to be called? Daddy Long Fingers. Okay, you psycho. Everybody say hi to Bad Duck. Bad Duck comes with dad jokes. We like that. All right. Thank you, Bad Duck. How's it going? All right. Thanks for stopping by. I mean, you can stay, but still, thanks for stopping by. All right. Let's see. Wayfarer parties need not plead special damages. All right. Reynolds also argues that the Wayfarer party's defamation claim fails for failure to plead special damages. But plaintiffs need not plead such damages where the statements are defamatory per se. With such statements, damage to plaintiff's reputation is conclusively presumed, and he need not introduce any evidence of actual damages. All right. Under California law, words which fall within the purview of Civil Code Section 46 constitute slander per se, with the effect that the utterance of such words is actionable without proof of special damage. Under New York law, a statement is actionable without alleging special damages if it tends to expose the plaintiff to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of him in the minds of right-thinking persons, and to deprive him of their friendly intercourse in society. Okay, I've never seen the word intercourse used in this context. I'm trying to be an adult, but still, that's interesting to me. All right. Moving on. One second. There we go. Oh, okay. Sorry, I had to fix something real quick. All right. What did I just do? Sorry, I moved my tab by accident. Intercourse to society. Please put out a video on Blake's big speech against child exploitation and abuse. She said she protects her children at all costs. So I have to kind of pick and choose what I make videos on just because I work full time, and then I usually do this during my breaks, or I have to do it after hours, and so it's kind of tricky. But I'll get to it if I can. Usually, if I feel like there's a lot of voices on a certain subject and I don't really have anything to add, I put that on the back burner. But it's not like I'm ignoring it on purpose. So, all right. Let's see. As to slander, New York law recognizes 4 statement categories as per se actionable, including those charging plaintiff with a serious crime and that tend to injure another in his or her trade, business, or profession. As to the statements concerning Baldoni being a sexual predator, there's no question these are defamatory per se. Perhaps the clearest example of libel per se is an accusation of crime. Okay. And they're quoting another case there. Reynolds' statements about Baldoni being a sexual predator is tantamount to a charge of serious criminality. And then it says, see First Amendment complaint, paragraph 8. Modern society justly reviles sexual harassers and abusers. Okay. Reynolds' statements about the other Wayfarer parties are also defamatory per se. The crux of the accusations is that the Wayfarer parties engaged in and or condoned sexual misconduct and took revenge on the victim of such misconduct. These allegations tend to expose the Wayfarer parties to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of them in the minds of right-thinking persons. Okay. A statement, and they're citing another case here, a statement is defamatory per se if it exposes any person to hatred, contempt, ridicule, or obloquy. How do you say that word again? Hang on. Obloquy? Okay. It just looks so strange that I don't like. I had to look up how to pronounce it again. Anyways. If you didn't know, it means like public criticism or verbal abuse. Okay. or which causes him to be shunned or avoided, or which has a tendency to injure him in his occupation. As to it ends with us and Wayfarer, it is well settled that a statement that impugns the basic integrity of a business is per se defamatory. On the face of these allegations, the pleading of special damages is unnecessary. Okay. Moving on to 5. The Wayfarer parties have pleaded actual malice. Under the Constitution, a public figure pleading defamation must prove, by clear and convincing evidence, the statement was made with actual malice, for example, with knowledge that it was false or with reckless disregard of whether it was false or not. Reynolds was intimately involved in and integral to Lively's concerted campaign of extortion to extract concessions and creative control over the film. Reynolds and Lively exploited Lively's false insinuations to coerce the Wayfarer parties to cede to them the power and authority to which they were not entitled. Reynolds was also directly involved in the marginalization of Baldoni from the rest of the cast and exclusion from the premiere. Having yielded under duress to their coercion, Wayfarer finally resisted the Lively Reynolds demand that they take the fall for Lively's disastrous promotional campaign. Then Reynolds and Lively pushed falsehoods from production with a lie combined with an untraceable smear campaign to the New York Times. My clothes are finished drying. I'll deal with that later. Reynolds and Lively, along with the Sloan parties, engaged in a coordinated effort to exaggerate benign interactions in service of a false narrative that Lively had been sexually harassed. They did so to instill terror in the Wayfarer parties and leverage it to accumulate power. This accumulation of power depended upon the ability to conjure and exploit ruinous allegations. The allegations were never true, and Reynolds knew full well or did not care whether they were true. Reynolds' insistence he believed his words, although not alleged in the FAC and thus not properly before the court, is an argument that he committed extortion, not defamation. And then footnote number 9 down here says, again, Reynolds' deep disdain for Baldoni does not imply he did not act with actual malice, even if allegations of ill will are insufficient to raise the inference. Evidence of Reynolds' ill will is probative of his mindset. Damn. All right. Reynolds also knew that the smear campaign narrative was false or acted with reckless disregard for its truth. Along with his co-conspirators, Reynolds got hold of communications between the Wayfarer parties from Stephanie Jones that disproved the claim the Wayfarer parties had orchestrated a smear campaign. Given that they had these materials, Reynolds, Lively, and the Sloan parties either knew that the narrative they later publicized was false or, at best, disregarded the evidence. It also would have been clear to Reynolds, who owns a marketing company, that the cause of Lively's bad press was her decision to hawk liquor and hair care products while promoting a film about domestic violence. The notion that the backlash was caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. There were obvious reasons to doubt the veracity of these statements, which Reynolds disregarded. The FAC alleges sufficient facts to infer actual malice. That's crazy, guys. Okay. Finally, while the FAC satisfies the Wayfarer party's pleading burden under an actual malice standard, it is important to note that 6 of the 7 Wayfarer parties are not public figures. For example, Heath, Sarowitz, Abel, Nathan, It Ends With Us, and Wayfarer. The mere involvement of a person in a matter which the media deem to be of interest to the public does not, in and of itself, require that such a person become a public figure for the purpose of a subsequent libel action. Okay. Because the FAC satisfies the burden of actual malice as to all the wayfarer parties, it is unnecessary to analyze the lesser standards. D. The wayfarer parties have adequately pleaded a claim for civil extortion. As set forth above, the proper law to apply generally is the law of California. Okay. As Reynolds concedes, California recognizes a claim for civil extortion. Reynolds claims the tort is limited only to extorting money through threats of prosecution, but points to no authority that California courts so limit the claim. Under California law, the exact contours of this common law tort are not so strictly defined. Civil extortion claims are based on the law of criminal extortion. Courts applying California law hold a civil extortion claim will not lie only where obtaining money was the aim, to the exclusion of other consideration. Okay. So they're citing here, extortion is the obtaining of property or other consideration from another with his or her consent, induced by a wrongful use of force or fear. Yep, that tracks. Okay, and then here, they're citing another case here. Extortion is the threat to accuse another crime or expose or impute to him any deformity, disgrace, or crime. The court is unaware of any case holding that there must be a threat of litigation in order to state a plausible claim for civil extortion under Twombly and Iqbal. Okay. Reynolds further claims that he cannot have engaged in extortion because he did not obtain property from the wayfarer parties by means of threats. But California law proscribes extortion, notwithstanding that the defendant ultimately obtained no money or property. But that's worded weird. That the defendant ultimately obtained no money or property by means of his extortionate threats. Here, the wayfarer parties have alleged facts sufficient to state a claim for civil extortion, based at least on the demand by Reynolds and Lively, that the wayfarer parties issue a self-destructive statement, taking blame for Lively's press woes, or else the gloves would come off and they would attack Wayfarer in the press. The FAC thus alleges that Reynolds and Lively expressly demanded consideration and, if the wayfarer parties refused, threatened their business or property interests. To the extent that the wayfarer parties' factual allegations do not suffice, the court should grant leave to amend. Okay. I heard Popcorn Planet is doing a Blake Lively and Justin documentary. I can't wait to see that one. Oh, that'd be pretty cool. Yeah, I would definitely watch that. Okay. Now we're on E. The FAC pleads a claim for false light invasion of privacy. For all the reasons set forth above, the law of California must apply to the wayfarer party's claim for false light invasion of privacy. Under California law, the false light claim is not duplicative of the defamation claim. The sole case that Reynolds cites for this proposition is inapposite. In Brooks versus Physicians Clinical Laboratory, the court noted that defamation and false light claims were based on the same single statement. Okay. Here, by contrast, Wayfarer alleges not only that Reynolds conspired to defame them by means of false and harmful statements, but also that Reynolds and others conspired to place the Wayfarer parties in a false light by means of false statements and distorting factual statements beyond recognition into falsehoods. Okay. We're skimming through this case law stuff, guys. Okay. Sorry. To the extent there exists any defects in the Wayfarer party's false light claim, the defects can readily be cured by amendment. Courts applying California law readily grant leave to amend claims for false light. And then they're citing a case here that says they granted leave to amend false light claims even in the face of California's stringent anti-SLAPP law. Okay. Of course, because the actions of Reynolds and his co-conspirators were carefully concealed, less particularity is required when it appears that defendant has superior knowledge of the facts, so long as the pleading gives notice of the issues sufficient to enable preparation of a defense. Consistent with Rule 15A2, the court should grant leave to amend to the extent it is not inclined to deny the motion in its entirety. All right, we're moving on to F here. The First Amendment complaint adequately pleads tortious interference claims against Reynolds. All right. The FAC pleads a claim against Reynolds for his tortious interference with Wayfarer and Baldoni's relationships with WME, a preeminent talent agency which represented Reynolds, Lively, Wayfarer, and Baldoni. The FAC alleges that Reynolds approaches Baldoni's agency, namely an executive at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a sexual predator, a phrase that uncoincidentally later appeared in the press, and at a later date demanded the agent drop Baldoni. Okay. The FAC further alleges that Reynolds and Lively, who are two of the most powerful stars in the world, demanded through their talent agency, which also represented Wayfarer and Baldoni, that the Wayfarer parties publicly apologize for so-called mistakes during production, or else the gloves would come off. When those coercive demands were refused, the FAC alleges that the gloves came off, and Reynolds, with Lively and Sloan, defamed Baldoni and Wayfarer to destroy their reputations and livelihood. Finally, the FAC alleges Reynolds' threats and demands induced WME to cease performing under its contract with the Wayfarer parties. Because talent agents are typically paid by commission as a percentage of their clients' earnings, it can be fairly inferred from these allegations that WME would fear its own economic harm from attacks on Baldoni and Wayfarer and would be coerced to drop Baldoni and Wayfarer to maintain more profitable relationships with much bigger stars such as Reynolds and Lively, who would generate larger commissions. Unsurprising. Sad, but unsurprising. While it's true, as discussed below, the proper categorization of the tortious interference claim may depend on fact issues that cannot yet be resolved without discovery, this does not warrant dismissal with prejudice. Pleading in the alternative is well-established practice, particularly where relevant facts may exist, which are not readily ascertainable by plaintiffs. Moreover, the court has discretion to dismiss without prejudice and with leave to replead. Okay. 1. California's tortious interference law applies. Cat Lady Ballerina, thank you for the $5. This filing is confusing. You're on page 20 and no one has mentioned Rule 26 once. No Rule 26 here, bro. This is a little more complicated. All right. Reynolds suggests that New York choice of law principles dictate application of New York law to the tortious interference claim, because that is where the tort occurred. Reynolds, a New York resident, makes the unsworn claim in briefing that he was physically present in New York when he made all of the alleged statements to WME. But this argument incorrectly presumes that the place where defendant's conduct occurred necessarily defines the place where tortious interference occurred. Under New York law, that does not follow. Courts applying New York choice of law principles look to the plaintiff's location, or to the place where the contracts or prospective relationships existed. The Wayfarer party's contract with WME was based in California, as were the prospective economic advantages they reasonably anticipated from the contracts with WME. California has the greater interest to the extent a conflict exists. California law applies. Okay. God, I feel like that was pretty straightforward compared to the rest of this. Okay. 2. Tortious interference is a tort independent from defamation. Reynolds contends that under New York law, tortious interference is duplicative of defamation, where the entire injury complained of by plaintiff flows from the effect on his reputation. First, Reynolds ignores the fact that the courts applying California law do not treat such claims as duplicative and, indeed, routinely recognize defamation as an independently wrongful act in claims for intentional interference with prospective economic advantage. Second, where a plaintiff plausibly alleges that it's economic... I'm trying not to sneeze right now, guys. I'm sorry. Where a plaintiff plausibly alleges that its economic harm was not directly and solely caused by generalized damage to reputation. Courts applying New York law will let defamation and tortious interference claims to coexist. A claim does not sound in defamation rather than tortious interference merely because the complaint contains allegations of defamation. All right, number 3, the FAC states a claim for intentional interference with contract. All right, guys, we don't have too much. We're down to the last 9 pages. 9 pages. All right, we got this. I got so used to just like churning these out every day because they were doing multiple filings every day for a while there, or it felt like every day. That when I took a break and I come back to this one, I'm just like, oh, I forgot how long these are. All right, we're almost there. We're in the home stretch, kind of, sort of, maybe. All right. Under California law, tortious interference with contractual relations requires 1, the existence of a valid contract between the plaintiff and a third party. 2, the defendant's knowledge of that contract. 3, the defendant's intentional acts designed to induce a breach or disruption of the contractual relationship. 4, actual breach or disruption of the contractual relationship. And 5, resulting damage. The third and fourth elements, which refer to disruption of the contractual relationship, as well as breach, create an actual conflict between California and New York law, because in New York law, only actual breach suffices. There's an actual conflict between New York law and California law. In California, but not New York, a plaintiff can state this cause of action in the absence of an actual breach of contract. Okay. Okay, we're skimming over some of this case law stuff, guys. Reynolds' other arguments that the specific details of the contracts with WME are not sufficiently described, and that Reynolds' knowledge of those contracts is alleged only in general terms, are easily curable issues which the Wayfarer party should be permitted to address by repleading. Reynolds himself is alleged to be a client of WME. In the context of an industry in which WME represents many prominent film actors and directors on identical or nearly identical terms, by procuring engagements for them and receiving commissions as a percentage of earnings, give rise to the interference that Reynolds, one of the most successful actors, understands the contractual terms by which talent agencies, and specifically WME, are bound. Further, contrary to Reynolds' disingenuous argument, the FAC clearly identifies Baldoni and Wayfarer as the Wayfarer parties who were represented by WME. Okay. 4, even if WME's contracts with Wayfarer parties were terminable at will, they were undisputably disrupted. Okay. In Ixchel Pharma, I don't know if I said that right, Ixchel Pharma, the California Supreme Court held that to state a claim for tortious interference with a contract terminable at will, a plaintiff must plead an independently wrongful act. Okay. An act is independently wrongful if it is unlawful, that is, if it is prescribed by some constitutional, statutory, regulatory, common law, or other determinable legal standard. The FAC clearly alleges an independently wrongful act by Reynolds. Reynolds attempts to downplay his defamatory statements that Baldoni was a sexual predator and that WME was working with a sexual predator as merely insulting. Oh, I see. He downplays the statements as merely insulting and therefore not wrongful. Okay. As discussed above, his statements plainly were defamation per se. Reynolds also ignores the threats made to WME that the gloves would come off if the Wayfarer parties did not take the blame for the blunders of Reynolds and Lively, threats they carried out by defaming WME's clients, harming the Wayfarer parties and WME. All right. 5, alternatively, the FAC states a claim for intentional interference with prospective economic advantage. Sorry, guys, I'm trying to skim through and make sure I didn't miss anything on the star chats here. Okay, we're good. I'm going to skim over some of this case law stuff. As set forth above, the Wayfair parties have pled an intentional interference with contractual relations claim, even if their contracts with WME were terminable at will, because Reynolds' defamation and threats wrongfully induced WME to drop them. However, in the alternative, the Wayfair parties' tortious interference cause of action may be deemed intentional interference with prospective economic advantage, because their relationship with WME probably would have resulted in an economic benefit to the Wayfair parties. Okay. To show an economic relationship, the cases generally agree that it must be reasonably probable the prospective economic advantage would have been realized but for defendant's interference. Okay. Here, the allegations give rise to an inference that WME was engaged in procuring engagements for the Wayfair parties, which were reasonably probable to benefit them economically. Indeed, discovery is likely to show that there were specific interested counterparties inquiring with WME to engage the Wayfair parties. Reynolds attempts to invoke the privilege of economic self-interest, an exception to international interference with prospective economic advantage, by suggesting that his alleged motive to seize control of the film production proves he did not act solely out of malice. But at that phrase, which reads in its entirety, the defendant acted solely out of malice, or used dishonest, unfair, or improper means, is not a requirement of California law. Reynolds does not claim he and Baldoni were actors competing for a role, and that his conduct was intended to cause WME to procure the opportunity for him instead of Baldoni. His defamatory statements and threats were intended to accomplish what they in fact did accomplish, that WME would drop the Wayfair parties from representation. Okay. Number 6, alternatively, the FAC states a claim for negligent interference with prospective economic advantage. As a further alternative, to the extent that Reynolds' intent was not sufficiently alleged, the cause of action for negligent interference with prospective economic advantage survives under California law. California law does require a plaintiff to plead a duty of care. However, although the FAC did not directly address this legal issue, there are facts pled which may give rise to a duty of care, such as the fact that Reynolds' promotion company, Maximum Effort, was hired to promote the film. Okay. As an agent, Reynolds may be under a duty not to recklessly damage the film's director, lead actor, and studio in the eyes of the public or the talent agency. Okay. Under California law, a duty of care may arise through statute or by contract, or may be premised upon the general character of the activity in which the defendant engaged, the relationship between the parties, or even the interdependent nature of human society. Because a duty of care may arise here, at minimum, the Wayfair party should be permitted an opportunity to replead the existence of a duty of care. Continually counting chickens. What's going on? How you doing? Okay. Reynolds is liable for his direct actions as well as by conspiracy. The Wayfair parties have not brought a standalone claim for civil conspiracy, as conspiracy is instead a legal theory by which parties may be made jointly liable for an underlying wrong. The burden of proving, let alone pleading, tort liability on a theory of conspiracy is not high. Okay. The Wayfair parties have pleaded ample allegations in connection with each cause of action against Reynolds to support the existence of a conspiracy at the pleading stage. For example, the FAC alleges that Reynolds and Lively made a joint threat to attack the Wayfair parties in the press unless they immediately issued a self-immolating press statement. The Wayfair parties have also pleaded facts that establish each claim against Reynolds based on his own direct acts. Finally, even if there exists some technical defects in the conspiracy allegations, the Wayfair party should be granted leave to amend. H, attorney's fees are not available to Reynolds under Second Circuit law. Okay. Even if the court grants the motion in its entirety without leave to amend, Reynolds still would not be entitled to recover attorney's fees because the Second Circuit does not permit the application of state anti-SLAPP laws that conflict with federal rules of civil procedure. Reynolds does not argue for the application of California's anti-SLAPP law, which, as the Second Circuit has held, is inapplicable in federal court because it conflicts with Rules 12 and 56 of the Federal Rules of Civil Procedure. Okay. Like I said, we're going to skim over some of this case law stuff. Notably, although Reynolds argues that the fee-shifting provision of Section 70-A1 is not a sanction at all, the standard for avoiding permissive sanctions under Rule 11, requiring only a non-frivolous claim, is lower than the standard for imposing a mandatory award of attorney's fees under Section 70-A1, requiring a substantial basis in fact and law to escape award of attorney's fees. In effect, Reynolds asked the court to create a rule that would automatically sanction any plaintiff whose non-frivolous defamation claims failed on Rule 12b6 motion, a mandatory sanction entirely inconsistent with Rule 11. The sole federal decision on which Reynolds relies in support of his argument for an award of attorney's fees in the event of dismissal without leave to amend is Bobulinski v. Tarlov. In Bobulinski, the judge found the defendant's entitlement to an award of attorney's fees under New York's anti-SLAPP law is substantive and not procedural, and therefore held that applying the state law in federal court would in that respect be consistent with law liberte. Importantly, however, the judge's ruling acknowledges that his decision in Bobulinski conflicts with the decisions of other judges in the Southern District of New York that have found that New York's anti-SLAPP law's fee-shifting provision does not apply in federal courts, including this court holding in Brady. Okay. In short, while the Second Circuit has not yet expressly addressed the applicability of New York's anti-SLAPP fee-shifting provision in federal court, virtually all of the courts in the Southern District of New York that have done so have found that law liberte applies to the bar the application of that law in federal court because it imposes a burden on plaintiffs that is inconsistent with the federal rules of civil procedure. Okay. The motion to strike should be denied or granted with leave to amend. The Wayfair parties incorporate by reference their arguments relating to the motion to strike Exhibit A to the FIC from their prior briefing. Okay. Conclusion. The Wayfair parties respectfully urge that the court deny the motion in its entirety. In the alternative, should the court be inclined to grant the motion in whole or in part, the Wayfair parties respectfully request they be granted leave to amend their complaint. All right. So, a couple of things here. Number one, I see this a lot when we finish reading these filings, where people will be like, why are they, filing more responses? Like they're just trying to waste time and shit like that. So this is how it goes. There's a motion to dismiss, which we saw Ryan Reynolds file. Then there's a response, which is what we just read. And now Ryan is going to respond again to this to try to bolster his claims and argue back against this. And then the judge can rule on it after that. So we won't see a ruling from the judge on this until we see another response from Ryan. In a couple of days, we should also be seeing responses to the motion to dismiss by Blake. And there might be even a couple more filings, I'm not sure, coming up then, but I'll keep an eye out for it. I just want to say thanks to everyone for being here and watching tonight. If you could hit that like button for me, it would really help me out. But before you go, since I have a lot more people here than I did when we started, I've been working on this project to help out Justin and Wayfair. I know there's not much I can do, but hang on, let me pull up and show you what I'm talking about here. I do need some help getting some more material for the rest of my project. Let me just show you what we're doing. I don't know if you guys happen to see this earlier. It was late last week, I think, actually. I don't know. It was Tuesday or Wednesday last week. Never mind. But I have people's voices and people's messages and stuff in these videos that show support. And I think it's really cool to hear from all you guys, or not all you guys, but some of you guys, and just know your voices and your stories, your backgrounds. So this is what I'm talking about here. This was the first one that I did. I have a short one here because I'm going to be doing a series where I do some short videos. This one's 2 minutes long. This one was closer to 20, but anyways, here's what I'm talking about, and here's what I need help with. So if you want to participate in this, please email me. I'm going to type it in the chat right now, guys. Hold on. please email me at this email address. It takes me a while to respond. I'm very slow at responding these days, but here's the email address, lackert@gmail.com. I'll also pin it in the comments when this video is over. So here is a little bit of what went on in that. And if you want to watch the whole video, I'll also pin that in the comments as well when this video is done. And let me just link to it right here. Okay, there it is. I'm a former victim of DV, and I appreciate your support for true victims. I'll participate. Yes, please email me. I could use the help. Let's see. And I'll try to reach out to some other creators too, just to get some help with this project, because this is something I'm really passionate about and I'm really excited about. So, and I know that Justin appreciates positivity and doesn't believe in like talking bad about people and stuff like that. So when I'm on my streams and I'm talking about these filings, I'm kind of ripping into these people sometimes. So that's for me. Okay. But this is for them. This is for the people who need support and the people who need to feel heard and feel like they have a sense of community that we're building here. So I'm just going to play a little bit of it for you guys. A movement of change and the victims of. I was also falsely accused of.
Survivor of casting.
Okay. So here's how this went. I was a victim of abuse and violence. I was also falsely accused of horrible things I would never do because my accuser materially benefited from turning the tables on me. So to the institutions who try to tell us what we can or should think, who try to put us in a little box and tell us things can only be one way. As a survivor myself, does my voice matter? How about theirs?
I was a victim of on-set sexual harassment. I am a survivor of casting couch sexual assault, and I support Justin Baldoni.
I'm a therapist, and I'm also a survivor of narcissistic abuse.
I am a legal assistant.
I am a veteran.
I myself am a victim of domestic abuse. I'm a mom of 2 beautiful boys.
I'm left-wing, although I don't see how that's relevant. As someone who's experienced SH, I believe Baldoni.
This is not a fight of man versus woman. It is a fight between right and wrong.
I am a survivor of SA. I stand with Justin Baldoni and those who need the truth to be told.
And the people who lie about.
Just not about
Good.
a lot of us men are really good at making friends and talking. Just not about anything real. But if it's about our insecurities or our struggles, our fear of failure, then it's almost like we become paralyzed. At least I do.
Jamie, Justin, your families, everyone at Wayfair who's feeling the weight of all of this right now. I know there's not really anything I can say to change things. In fact, I'm actually going to ask you for a favor. It's to not let this stop you from doing your work. I know you're limited in what you can say and do right now with the ongoing legal case, but this won't go on forever. And when it's over, we're still going to need you. So I'm going to end with this little reminder.
So some of the ways that I've been practicing breaking free of this behavior are by creating experiences that force me to be vulnerable. So if there's something I'm experiencing shame around in my life, I practice diving straight into it, no matter how scary it is, and sometimes even publicly. Because then in doing so, I take away its power.
All right. Well, if you haven't watched it yet, like I said, you can go to that link that I just posted. P. Mahone says, I thought I missed the window to leave a voice message. Well, this is an ongoing project now. I decided it has to be longer than just the one video. So please do email me at that email address. Like I said, I'll pin it in the comments down below as soon as this live stream is over, so you can read it in the comments section. And I would really appreciate anyone that reaches out. Like I said, it might even take me a week to get back to you. Like, honestly, it takes me forever to answer messages on social media and stuff these days. But please do reach out. I could really use your help, and I'm sure everyone will appreciate it. Don't forget to hit the like on this stream, guys. And if you could, share that video, the one that I just linked. Share that video. Tag it. Try to get it in front of more eyes so more people can participate, so more people can share their voice and share support. And just, I know the message that Justin really wanted to get out and Wayfarer as a whole wanted to get out with this movie was, like reaching out to people who needed hope, who were stuck in DV situations and stuff like that. And so I would really just like to continue doing this for them, to give them a little tiny piece, even though I'm, obviously a very small channel, a little tiny piece of what they had hoped to do with the project. I want to make sure we carry that on and do what we can for them. So, all right, here we go. Let me pen that real quick. And I'm going to send you guys over to, let's see. I'm sending you guys over to, I don't know if she's still on. Let me see. I was going to send you over to Tamara. Hang on. Oh, let's go to Vice Baby. This is my friend's son. He's pretty cool. Just do me a favor and tell him Lauren sent you and send him much love. Put lots of bacon emojis and robot emojis. This is the Bacon Bot Army, bacons and robots in his chat. Tell him Lethal Lauren sent you. And I'm going to do a quick recap video of this filing. It'll be like a 5-minute video where it's like just shortened down for those who didn't see it all or can't listen for an hour or however long it took me to read that. And please don't forget, like I said, to share that video that I just showed you guys. Tag the crap out of it. Just get your friends and family who want to participate to message me as well, so I include in their voices. It's all anonymous, and I'm totally cool with written statements as well if you are too shy to share your voice, but hopefully you will. So, okay, thanks, guys. I will. I'm sure I'll see you again very soon. If not tonight, then tomorrow. So, bye, everyone. Thank you for being here.